My name's Mackenzie, and I started a GoFundMe for the adoptive mother of a nonverbal autistic child. The mother had lost her job because she wasn't able to find adequate care for this autistic child. So she really needed some help with living expenses, paying some back bills. So I launched a GoFundMe to help support them during this crisis. And we raised about $10,000 within just a couple of months. I think that the surprising thing was by telling a clear story and just really being very clear about what we needed, we had some really generous donations from people who were really moved by the situation that this family was struggling with.
GoFundMe is the world's #1 fundraising platform trusted by over 200 million people. Start your GoFundMe today at GoFundMe.com. That's GoFundMe.com. GoFundMe.com. This podcast is supported by GoFundMe.
I'm Kevin, and in this episode, we're going to continue our look at what has become one of the more controversial cases in recent times, the murder of Charlie Kirk. Content warning, this episode contains discussion of murder. Well, Anya, in this day and age, when you have a high-profile case, one thing that, frankly, both sides need to be aware of and keep in the forefront of their minds is how is this case being presented and shared with the world at large? For the attorneys on the defense side, that is especially crucial because you need to protect the rights of your client. Just because a person is charged with a crime, as Tyler Robinson has been charged here with the murder of Charlie Kirk, that does not mean that that person is guilty. And even if that person is factually guilty, that doesn't mean that there is evidence to prove them legally guilty. You have to protect their rights. You have to do what you can to ensure that a jury pool is not tainted against him. At the same time, people on the other side want to do what they can to ensure public access. In this case, this Charlie Kirk case, the media has been very active in trying to defend public access, right? So you have to balance all of these interests against each other. And I think that's going to be the primary focus of what we talk about today.
Great. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases.
We're The Murder Sheet.
And this is The Murder of Charlie Kirk, the case of Tyler James Robinson, the media. I think it's always helpful, Anya, when we acknowledge our own biases. And would it be fair to say that we have a strong bias in favor of as much public access as possible?
Yeah, I would say that's consistently our strong bias. It's not to say that we don't understand arguments for the contrary at certain points, but I would say that you and I, as people who cover crimes, me coming from a journalism background, you always being, quite the fan of journalism, I think we tend to like to see a lot of sunshine, a lot of public access on things, frankly, especially a highly politicized case like this, where there are political ramifications. It's a big, high-profile thing, and I really think that for all the problems that a high level of public access to a case can cause, personally, I think it's good for society when people can observe the wheels of justice in motion.
100%. I also like what you say about how we understand the arguments on the other side. Just because we love public access doesn't mean that we believe there has to be total public access of everything at all times.
No.
Because that can, in some instances, affect the rights of the defendant.
I will just say, I want to say this. It's interesting in this case because oftentimes, I think in the case that we, covered pretty extensively, obviously the Delphi murders case, it was the prosecution that was being very cautious about public access. And we were critical of them at times for that. So it's a situation where, and I understand now better than when it was going on why they were doing that. And I think some of their decisions made sense in retrospect. But at the same time, it's interesting in this case, it's flipped. It's actually the defense saying, no, we're concerned about this. So you can see both sides it just depends on the case, I guess. But both sides can kind of be a little bit more cautious about what's getting out to the public.
And it's important that you bring up the case of the Richard Allen case, the Delphi murders, because it's easy to say, oh, the side that's wary of public access is the side that has the weaker hand. The prosecution in that case had a very strong case. They won. Whatever concerns they had about public access, it wasn't them trying to hide a weak case. And so when we discuss the public access issues in this case, and we see the defense arguing against public access, we should not assume that means, oh, they think they have a really terrible case.
I don't think kind of, blanket assumptions like that are particularly helpful. I mean, I guess sometimes everyone makes a blanket assumption, but I think there can be strategic reasons going behind this. I think there can be reasons around working well with your client or protecting witnesses if you're the prosecution, or there's all kinds of reasons you can be more cautious and want restraints put on public access.
Yeah. And it's funny you mentioned restraints because the first thing that come up kind of deals with restraints a little bit and quite literally. Very early on after the arrest of Mr. Robinson, his team filed a motion saying, we don't want him to have to wear restraints when he comes to court, even for pretrial hearings. We also want him to dress in civilian clothes when he comes to court, even in pretrial hearings. I'm going to read a little bit about this. Quote, the use of courtroom restraints has been litigated most often when the restraints are used during jury trials. That's when the dangers of unfair prejudice are most severe, and where, if any restraints are to be used, the usual course is to ensure they never become visible to the jury. Yet the reasons for the limits on courtroom restraints apply more broadly. They weigh in favor of applying these limits to pretrial proceedings. I'm going to go down a little bit. They also write, by necessity, judges are trusted to be less vulnerable than lay jurors to this and other forms of unfair prejudice. However, the psychological reality is that human beings who serve on the bench are likewise not immune to such subconscious and subliminal influence from seeing a human being enchained to protect others from him, end quote. So they're saying even the judge see the person in restraints might cause some sort of a bias.
The judge is going to yell gadzooks and jump into someone's arms like Scooby-Doo. I mean, I'm sorry, this seems a little bit over the top. I don't know. I know what they're saying, but
they also say, hey, if he's wearing a lot of restraints, maybe that's going to affect his ability to communicate effectively with his lawyers.
How?
I don't know. They also say that if he is seen in all these pretrial hearings wearing clothes, the prison garb, these pretrial hearings are shared all over the world. People take pictures of them. That might influence a jury.
See, that one's, I feel like, a better argument because I could see that where people are conditioned, oh, he's in chains, he's a criminal, he's dangerous. And I'm seeing it all over social media. That I feel like is a stronger argument than oh, it might spook the judge. I don't know. That just seems a little bit silly. But I think the other one is not silly. I think that's reasonable. But I guess, a lot of this also is a safety concern. There's an element of you don't want a crazy situation erupting in the courtroom where a defendant goes for somebody's gun. That would be a disaster. So I get what they're saying and I actually understand. And also I think this would be something that would build a lot of rapport with your client if you're able to get them in a more comfortable situation for these pretrial hearings in more kind of a humane you're not chained up and you're wearing normal clothes. I think that can be a great win. So I get why they're doing this. But I feel like safety issues kind of trump a lot of things at the same time.
That's a great point, and I want to come back to it in a second. But first, I want to read another excerpt from this particular motion from the defense. Quote, illustrative of the magnitude of the issue, on September 16th, 2025, at 3 p.m., Mr. Robinson appeared for the first time in this case from the Utah County Jail via WebEx. The hearing was streamed live and covered by media outlets the world over, including the BBC, Al Jazeera, ABC, CBS, NBC, Newsweek, NPR, The Daily Mail, Fox News, CNN, and countless others, generating approximately 18,000 news search results. Mr. Robinson's physical appearance alone was and is subject to endless scrutiny and speculation. One article described Mr. Robinson during his initial appearance as emotionless and staring blankly ahead, and sporting slightly mussed locks, several days' worth of facial hair, and wearing a green suicide smock. With each development in the case generating thousands of articles and comments online, the likelihood of potential jurors seeing and drawing conclusions regarding Mr. Robinson's guilt and or deserved punishment from obvious signs of pretrial incarceration will only increase, end quote. So I wanted to highlight, first of all, they're doing media criticism there.
I know. Yeah, there you
and
go.
And we can discuss the substance of that in a moment. But this is also something, that sort of thing we're going to see a lot of in this discussion. They're going to be very critical of the news media. What do you think about the substance of that?
I get what they're saying. I'm not going to just be reflexively dismissive of it. I think I get that. Personally, and this may just be me, maybe listeners agree or disagree with this. Personally, like, I believe, again, to go back to a case where there was also, pretrial incarceration and he had pretrial hearings. These were not televised, but he would appear in chains in prison garb. Richard Allen, I believe he's guilty, right? I believe he killed those girls. But when I was seeing him like that, prior to my mind being made up either way, part of me felt really bad for him. Like, I didn't see him and be like, oh my gosh, he's so, like, he must have done it. I was like, oh man, like that looks really rough. And I feel like I've sympathized more with him from that than like actually having a negative view of him. Like some of the evidence would make me be like, well, I don't know, maybe, like that sounds pretty bad. But I feel like I wasn't, if anything, when I see someone like that, I almost kind of have a bit of a jolt of sympathy. And then, it's more of like reading about what they did or were accused of doing, that might make you feel a certain type of way based on the evidence. But for me, that alone is never like, okay, yeah, they did it. I don't know. Maybe what do you think?
I think we should take what you just said and like shine lights on it, because you're making an excellent point here, which is essentially a lot of what they're saying about the alleged effect of this on jurors is speculative. They're assuming people will see this and, oh, he must be guilty. I think I haven't seen proof that's necessarily true. I actually had a similar reaction when I saw Richard Allen come out in prison garb and in shackles. This is out of the sight of the jury in the pretrial hearings. There's just something about that sight of seeing this little guy surrounded by all these guards and in shackles. On some level, you can't help but feel a little bit of sympathy, even though it's misguided. So I'm not even sure if this sort of visual is necessarily bad for their client.
I do think, now I don't have studies in front of me. I know for a fact there's been at least, looking into attire of a defendant. I think one of the famous things is like, there's like almost like don't wear red, like, like I think there are studies or, kind of academics who look into this stuff who do feel that you can prejudice a jury with this. I know there was a Supreme Court ruling that found like, it would prejudice a jury to see the defendant in prison garb during the trial. So I'm not going to dismiss it and say, oh, no, everyone must feel like we do and just feel bad for the guy. We might just be weird, and like everyone else is sitting there being like, no, that would kind of freak me out. And I would kind of like almost think he's a criminal, like even subconsciously. And I'm not going to dismiss the possible phenomenon, and I think there are possibly some resources there that do indicate that it's a problem. But yeah, I think I guess I'm open-minded on that either way. When we started the Murder Sheet, we didn't really know if podcasting was even going to work out for us in the long run. Like, what if no one listens to us? That would be awkward. I'm really glad we tuned out those doubts and went for it, because it's been an absolute dream come true. But the kind of uncertainty we face is what stops people from betting on themselves, chasing their dreams, and starting their own businesses.
For all of you out there looking to kickstart your own dreams, partnering with Shopify is one of the best decisions you can make. It gets you on the right track from day one. They take the uncertainty out of business.
Shopify is your one-stop commerce platform that supports millions of businesses around the world.
Shopify makes you efficient and fast. You can upload new products, improve existing products. Shopify's AI tools can help you with product descriptions, page headlines, and better product photography.
And don't worry about nobody buying your products. They help you get the word out. Shopify puts the power of a whole marketing team behind you. You can create email and social media campaigns with just a few clicks.
Shopify supports you with inventory management, international shipping, processing returns, and more. Whatever the challenge, they're there to make things quicker and more convenient. It's time to turn those what ifs into with Shopify today. Sign up for your $1 per month trial today at shopify.com/msheet. Go to shopify.com/msheet. That's shopify.com/msheet.
Enough with overcomplicating your wardrobe. Stop buying trendy, cheap stuff that doesn't last. Curate your style with high-quality pieces that you can mix and match. Our wonderful sponsor, Quince, can help you out with that.
They are all about accessible luxury. These are the premium, everyday essentials that you can wear all the time, even as the seasons change.
We love their comfortable, lightweight Mongolian cashmere sweaters. They're perfect for spring. We're also excited to try out their linen bottoms and shorts and European jersey linen t-shirts.
Not only will you be getting high-quality clothing for less, it's also important to know that Quince only pairs with ethical factories and artisans that set rigorous standards for craftsmanship. They save you money by cutting out the middleman.
Quince's wonderful silk pieces have been some of my go-tos this year. I love their black washable silk dress and black washable silk skirt. They elevate my style while being so easy to wash and maintain and pair with other clothes.
Right now, go to quince.com/msheet for free shipping and 365-day returns. That is a full year to build your wardrobe and love it. And you will. It's now available in Canada too. Don't keep settling for clothes that don't last. Go to quince.com/msheet for free shipping and 365-day returns. Quince.com/msheet.
If you work in university maintenance, Granger considers you an MVP because your playbook ensures your arena is always ready for tip-off. And Granger is your trusted partner, offering the products you need all in one place, from HVAC and plumbing supplies to lighting and more. And all delivered with plenty of time left on the clock, so your team always gets the win. Call 1-800-GRANGER, visit Granger.com, or just stop by. Granger, for the ones who get it done.
You're easy.
I'm just saying, from my personal experience, I don't feel like I have that. But again, like maybe I do, and I just am not aware of it.
Other people might. I'm saying I would have liked to have seen more specific reasons and not just speculative here.
Like maybe cite some of the studies, perhaps. Like, these criminologists or these sociologists looked into the effects of this, and here's what they found. That might have been helpful. I don't know. I guess it's not an academic paper; it's a legal filing.
In the response, the representatives of the state basically raised some of the points you made, Anya, earlier, which is that having a person shackled, that could be a security concern. They even go so far as to say that if there's some sort of a disturbance, having a prisoner or prisoners in prison garb would make it easier for them to be subdued and identified. That was their response. basically that, yes, we have to balance all of these interests, but one interest is very important as security, and that has to come first. Do you have any response to that argument?
I mean, like that it's a security issue fundamentally, and like if he gets out, then they need to be able to, see the prison garb. Yeah, I mean, that makes sense. I understand that. At the same time, I mean, you could always make the argument, I guess, that he could get out during trial and then he's going to be in civilian clothes, right? Like, I guess it's just complicated, right? And, in maybe there should be more consideration that if a trial is going to be televised, that the images seen from that are going to influence potentially a jury pool. We live in a different era than we did in the 70s when I think this original Supreme Court around prison attire or jail attire during a trial kind of came up. And this is a time where we're spreading around TikToks taken from Court TV's coverage of all of this. Like, we're seeing everything and it's lingering, and people who are not watching it live can go back and watch it later. So maybe the defense has a point that we should be considering more of the holistic what's getting out there to the public in the long term. I'm open to that.
I'm going to read you what the judge ultimately wrote in his ruling on this issue. Quote, upon balancing the interests at stake, the court concludes that Mr. Robinson's right to the presumption of innocence and an unbiased jury supersedes the security concerns of dressing in civilian clothing in this case. The media interest in Mr. Robinson's trial is arguably unprecedented in the state of Utah. Photographs and visual recordings of Mr. Robinson in jail clothing will likely be shared and disseminated in various public platforms. There is a strong likelihood that a substantial number of potential jurors in Utah County will view these images and may associate Mr. Robinson's jail clothing with indicia of guilt. The danger of prejudice is compounded by technological advancements that allow the images to be manipulated in ways that do not accurately reflect the truth of the court proceedings, end quote.
Yeah, I feel like that's pretty reasonable.
He's saying, yeah, there is a danger here. These images are going to be seen by potential jurors who may draw the wrong idea from him. He goes on to note that because of the circumstances of this case and the trial, Mr. Robinson is always going to be the only defendant, the only person from jail in the courtroom. So people shouldn't have a hard time identifying him in a disturbance.
And, I mean, I think, you'd hope that they just have professional, competent people in the courtroom making sure everything's okay. Maybe this makes it a little bit more complicated for them, and that's unfortunate, but I feel like the nature of social media and the nature of our media environment now where we're saturated with images, even if I feel like personally when I see someone in that state, I feel bad for them, that doesn't necessarily mean that everybody feels that way. And maybe I'm fooling myself. Maybe I think that, but then maybe I would secretly, maybe there's like levels to it where we all kind of have mixed feelings about it. So I feel like this is a reasonable and prudent and cautious way to approach it.
So then let's get to the issue of should he be shackled? And the judge acknowledges Mr. Robertson has no criminal history. There's no evidence whatsoever that he's been disruptive or disrespectful or been a danger since he was charged. And he also agrees, quote, visual recordings and photographs of Mr. Robertson shackled may give the impression that he is dangerous and may undermine his presumption of innocence. He goes on to add, though, quote, on the other hand, the charges against Mr. Robinson are serious. If convicted, he faces potential sentences of life in prison or death. Though these proceedings were focused on legal matters, both Mr. Robinson and court patrons are likely to feel strong emotions. The landscape that lies ahead requires thoughtful and focused work, and the court would not tolerate disruption or commotion that could have been prevented or mitigated by strong security protocols. End quote. So ultimately, he kind of comes down in the middle. He wants him to be shackled, but he doesn't want to allow the court. He doesn't want the court to allow media to take images of Mr. Robinson shackled. I'm curious, what's your response to that? Because in a way, that is limiting public access to a certain degree.
Yeah, it is. It is. I mean, given the circumstances, I can understand where this judge is coming from with this. It feels like that's pretty reasonable. I mean, I think it would be pretty wild to not have somebody, I don't know, shackled in this instance where it is a violent crime. And, I just, it's a highly violent, like somebody died. So, I feel like the judge is trying to like balance safety with everything else.
While still protecting Mr. Robinson's right to a fair trial. Yeah, who knows how a person might react if you're sitting in court and you hear you're going to be sentenced to death, or you're going to be sentenced to some terrible sentence of people saying terrible things about you. Who knows?
Wait a minute. I have a question. But like, is this for pre-trial or is this for the trial as well? Because I feel like that's also a bit of a, like, obviously, the big question would be for me, like, are the jurors seeing this too?
Right. This is for pre-trial.
Okay, so yeah, like, but potential jurors could see it, but that's why they're having him not be shown in shackles. I always feel a little bit iffy about restricting any sort of public access, but I mean, I can understand it.
Yeah. He could be hearing terrible things affecting his fate. Yeah.
Yeah. I mean, I think the judge is just trying to balance a lot of complicated issues in an unusual case. And it's unusual because of who the victim was and because of the victim's prominence within, sort of political circles. There is an element here where it's just kind of generated a lot of attention.
So that was the first kind of public access issue. There have been a few others since then that they kind of get intertwined. And so I'm going to talk about all of them and some of the arguments for them. At one point, the defense filed a motion about some evidence. I'm sorry to be vague. That motion about that evidence is not available because they've requested that it be kept from the public because they say, oh, we may have objections to this evidence, and evidence that is inadmissible, there's not a guaranteed public right to that. And it might, if this evidence that we allude to in this motion is exposed to the public, that might interfere with his rights. So there's arguments over whether or not that particular motion should be made public. There's arguments about other motions. There's arguments about, not only are there arguments about cameras in the courtroom, the defense has filed a motion arguing against cameras in the courtroom, and they want that motion to be kept secret. So they even want their arguments about whether or not things should be kept secret to it themselves be kept secret. And so I want to talk about some of the arguments in those issues, if that makes sense.
Yes, that makes total sense.
Okay. Yeah, it's kind of confusing. So I want to talk about some of the things the defense has done. They've written, quote, while open criminal proceedings give assurances of fairness to both the public and the accused, there are some limited circumstances in which the right of the accused to a fair trial might be undermined by publicity. I think we could all agree with that.
Oh, yeah, certainly.
The classic example goes back to the 1950s. Sam Shepard,
who was guilty,
was tried in an atmosphere and an environment of intense media publicity that the Supreme Court later found that this was unfair because of all of this publicity. So there are circumstances where publicity might undermine a defendant's rights. The defense writes, quote, at this early stage of proceedings and prior to any adversarial testing, disclosure of initial evidentiary reports will only serve to insert potentially inadmissible evidence into the public narrative, saturating the coverage of Mr. Robinson's case, and runs a high risk of tainting the potential jury pool. So again, they want to file a motion about some evidentiary report that apparently is incriminating to their client, but they don't want the public to know about what that evidence is because they say, who knows, maybe we'll come up with a good argument to make it inadmissible. I'm just curious on the face of it, what is your reaction to that?
I don't know. Can you run it by me again? I'm not sure if I'm like completely understanding what that means.
They want to file a motion about an evidentiary report, some sort of report that's been generated about a piece of evidence.
Okay.
They don't want the public to know what's in that report, even though they're making a motion about it, because they say what's in that report, who knows, maybe it won't be admissible. And if it's not admissible, why should the public even hear about it at all? And just let us file this in secret. Does that make it more clear?
Yeah, that makes it more clear. I mean, I don't know. That makes me a little bit uncomfortable. I mean, I kind of feel like the the point of public access is so people are, watching what's happening here. I don't like, I mean, also, I mean, I don't know. I guess without knowing what it is or what's going on with that, it's a little bit hard to say. Maybe it makes a lot of sense. And, I mean, I guess on some level, I just kind of, I respect defense attorneys who are zealously advocating for their clients. And it seems like they're really trying their best on a number of different levels to represent him and really, make his chances at trial as good as possible. So, I mean, I respect that. It's a bit frustrating when you're on the media side of it, though, where it's like, okay, but can we have the information on the case? Like, I don't. I mean, I mean, why can't that play out in the public setting?
They write, quote, defense efforts to exclude this evidence as unreliable would be futile if the evidence has already reached the jury pool through pretrial publicity.
I mean, that's assuming, I mean, I don't know. Listen, I know some people like to denigrate our jury system and be like, oh, the jury, they're just going to convict you if you're wearing a red shirt or whatever. Maybe some jurors will. I think there have been bad juries. I'm not one of those people who's like, always respect the jury. We're the jury respecters. No, I mean, like, the O.J. Simpson jury botched it, like, I'm not going to be, like, nice to them. But that doesn't mean that I think that, like, I think a lot of people in cases I've followed where I've like, or watched or whatever, the jury takes it very seriously and they try their best to come to a fair conclusion based on the facts they've heard and they take it seriously. I'm not saying every jury's perfect, but I'm just saying that, like, if that's not presented at trial. Also, I think sometimes this kind of overestimates how many people care about true crime.
That's what I was going to say. I think one problem I have with a lot of the defense arguments on this issue is, we see a potential issue here with tainting the jury pool. Therefore, we just have to lock everything down, just deny access. And I think there's a lot of remedies already in place for this sort of thing, which is to have a very vigorous questioning process in the jury selection process. As you say, a lot of people, God bless them, don't follow true crime. I use the football example. I don't know who the quarterback of my local football team is. I have no idea. People who are football fans would be astonished by that because to them it's very, very important. We follow true crime. We know a lot of details about these cases. People who don't follow the true crime wouldn't know about it. I think through a vigorous jury selection process, asking the right questions, you can weed out people who have been exposed to this.
I jokingly sometimes call the people who are not into true crime the normies, right? Because it's like they're the normal people who aren't really getting all morbid. When you talk to them, they might know a little bit about some really high-profile cases that are dominating the mainstream media or cases that previously dominated the mainstream media. Things like maybe they might ask you about Nancy Guthrie. They might ask you about, they might talk about O.J. Simpson or John Benet Ramsey a little bit. Like cases that at one point were everywhere. But they are not following this in any sort of depth. And frankly, I'm not saying they don't care. I mean, And if you don't think those people exist, I encourage you to expand your friend group because it's great. I mean, it's great talking to people who don't care about true crime because I feel like a lot of them are actually more open-minded than some of us who are in the true crime field because we've got all these opinions and all this stuff. And they're just like, hey, what's the evidence? All right, that makes sense. Like, I mean, like it's kind of refreshing, I guess. But we talk to, neighbors, people in our community, people we run into, friends that, I mean, I have friends where they're just not into true crime and I'm like telling them about what's going on with some of the drama and they're like, oh my gosh, are you okay? Like, like it's a situation where you have to, most people just don't care. And this is something where we are in a siloed media environment. The monoculture is largely dead. We're not all looking at the same 3 channels on TV, getting our news from them. We are having our computers and our phones tell us things that they think we want to hear based on our previous news consumption. And there's ways for people to be completely siloed off from any of this. And I think come into it with a completely open mind.
To go back to my football example, it's entirely possible that as I consume media, maybe I've at different times encountered headlines about a quarterback locally. Maybe he has a contract issue or something like that. So I may even have a little bit of information about the football team and the players, but that doesn't mean I have any hard and fast opinions. And that doesn't mean that I wouldn't change my mind on those issues if I get more information.
And you don't care. You're not emotionally invested in that.
Yes. So again, a rigorous voir dire, get jurors who don't have hard and fast opinions. And I think a lot of this is mitigated.
Yeah. And I think, stuff like the image-based stuff around him being in prison garb, that's something where someone could be scrolling through and just see a picture. And maybe that influences them a little, even if they don't care that much. So I understand mitigating that. But preventing public access to all these, different things, I think that's overkill, personally. I understand why the defense is doing it, though. I'm not criticizing them. But for me, it's it just seems a little over the top. But, I mean, I get it. They want to be as cautious as possible.
I'm going to read another quote from the defense. Quote, "The court should also be dissuaded of the notion that bias in the potential jury pool created by disclosure of evidence that may ultimately be ruled inadmissible would dissipate with time in this particular case. We no longer live in times where cases like Mr. Robinson's are subject to a 24-hour news cycle, with each article or post easily replaced in the minds of the public by a new story of the day. The appetite for this case is voracious, and each new development in or out of court proceedings does not become an archived story. Rather, it becomes a part of ongoing narratives that live and breathe on social media and the internet generally. The evidence at issue here would undoubtedly become part of any number of narratives and conspiracy theories pervading the public sphere and be repeated ad nauseum up to and even during Mr. Robinson's trial, regardless of this court's admissibility determinations. The only way to prevent potentially inadmissible evidence from becoming part of the narratives that lead to bias and tainting of the jury pool is to not file the potentially inadmissible evidence publicly," end quote.
Yeah. I mean, I think they're right about...
I think they're right and wrong.
Yeah, but I think what they're saying about the living, breathing, kind of seething mass of true crime where it's all part of this never-ending story, that's accurate.
I think that is highly accurate for people within these silos that you speak of, people like us, people who follow true crime cases. We haven't even covered the Guthrie case on this program. I'm sure we've remembered every single detail and are making little narratives in our mind.
Mm-hmm.
That's how people like us think when we consume true crime. I don't think this is how most potential juror members think. So I think they're accurately describing something real, but I don't think it is pervasive as they seem to believe. What do you think?
I think you're right. I mean, the nightmare scenario is you get somebody like that on a jury, right? And I think, that is always a possibility. And that's what's scary about this. It's all it takes is one person who's completely, made up their mind already one way or another and is not treating the process with any sort of respect. So that is a concern. I mean, I understand being concerned about that. I think they've described true crime somewhat accurately, where it's a kind of this like attracts a kind of, you know, the obsessives. And I say that as somebody who is in that category. I'm not critical of it. It's just more of like, we're all going to be paying a lot of attention to it. Other people aren't. You kind of want the people who aren't obsessed with it. You want people who are open-minded. But as for, yeah, I mean, I mean, are most people in the true crime space? No. I would say most people are probably not. That doesn't mean those people who are not are necessarily like don't follow any true crime stories. But as I mentioned, they follow the big ones. This is a big one, but I wouldn't say it's Nancy Guthrie level at this point in terms of the coverage. Nancy Guthrie got like wall-to-wall coverage for days, and it's still something like people who are just not into true crime, they'll, like, when we're talking to them, they'll, oh, you guys have a true crime podcast? What do you think of that? Whereas this one, not so much. I don't know why some cases are that way and others aren't. This one, I think, is a top tier one in terms of getting a lot of high profile coverage. It's maybe not quite broken through in the same exact way or to the same exact extent, but I mean, it is big enough that I think it's a reasonable concern for the defense. Do I agree that everything should be shut down as a result? Not really, but I mean, I can see why they're making the argument, I guess.
I want to read something that the media filed in this case as a response to some of these. As I say, some of these pertain to different things. Cameras in the courtroom, keeping evidentiary motions secret. This is the media quote. No one trusts what happens in a secret criminal proceeding. Not those who support the prosecution, who wonder whether the case was properly presented. Not those who support the defense, who wonder whether the defendant's fair trial rights were respected. And not even dispassionate observers who are deprived of the right to see how the judicial system works. Along the way, the court's credibility is irreparably damaged, perceived accountability for alleged crimes is undermined, and public confidence in the result is diminished. This is why public judicial proceedings are a bedrock and axiomatic principle of our system of justice, not as a quirk of history, but as a founding tenet embedded in the Constitution, end quote. I find that compelling because I think we saw something like this in Delphi. Whether you support the prosecution in that case, whether you support the defense in that case, whether you are just in the middle trying to figure out what you think about that case, a lot of people had doubts and concerns in that case because of the fact that information about that case and that trial were held so closely to the vest. I think that ultimately undermines some public confidence in the verdict.
I agree.
And I think they are correct that people don't trust secret proceedings.
I'm going to tell you something just from the reaction we've gotten to our first episode. I think there are a lot of people who are concerned about these proceedings, who are concerned that there's a bigger story here. And I'm not going to just dismiss them or say, oh, they're conspiracy theorists, they're wrong. I understand where they're coming from, even if I disagree. And even if I feel like their conclusions are likely wrong, I think it's important to showcase what the evidence is and showcase how this all works. Because I think if you don't do that in this case, you do run the risk of it having a much longer life as something where people are saying, oh, well, you know, there was a cover up and there was a cover up because it was secret and therefore we can't know. And it's like that. You don't want to get into that. That undermines everything about our system.
Yeah, I'll repeat something we said early on in our Delphi coverage during the pretrial phase of that case. We have a bias in that case too. What we want is at the end of the day, we want there to be a verdict in that case that is properly understood by anyone interested in the case, and it's a verdict they have confidence in because they have information enough to thoroughly understand it.
That's right.
And that aim is harder to accomplish if information is held close to the vest.
That's exactly right. Even if those reasons for holding it close to the vest are valid or they are understandable, sometimes this stuff can be bigger than just one case. It can be about public confidence in our justice system.
I'm going to read another quote from the media's response here. Quote, the defense's constant incantation this case is somehow unique and has drawn significant public attention cuts exactly the opposite way. That is precisely why it is so critically important that the public be allowed to observe these proceedings and see the court in action, ensuring defendants' rights are protected and the prosecution's ability to present its case is preserved. Again, these are bedrock principles of our system of justice enshrined for hundreds of years. They are not controversial. This court should not depart from them. What do you think?
Yeah, it's pretty stirring. I mean, I've expressed sympathy with the defense position here, and I've also expressed that we should be knowledgeable about how our media environment has changed and therefore be able to tweak protections of defendants' rights along with that. But I also don't think we should be throwing the baby out with the bathwater of having public access to trials, because it's like, yes, would everything be technically safer if we just had secret trials in a basement with no one allowed in? Yes, but obviously we can all understand when I say it like that presents the opportunity for pretty
abuse
and egregiousness. That's not what we should want, even though that would technically lock everything down. So there's obviously needs to be compromises. There obviously needs to maybe be tweaks, but should everything be just, secret and silent? No, absolutely not. That is completely antithetical to how this is supposed to operate, frankly.
The media also says, quote, no court has ever held that the mere possibility that evidence will be excluded at the trial court level is sufficient to prophylactically seal all evidentiary motions until a ruling is made. To reach that conclusion would turn the presumption of access on its head and permit every single motion to exclude evidence to be filed under seal, contrary to the very right of access.
Mm-hmm.
Yeah, I think that's a good argument.
Also, I guess I just don't really understand that argument in the sense that, if it gets thrown out, then the jury's not going to hear it at trial.
The argument is, just the fact that it is admitted publicly, there's going to be so much talk about it.
Yeah, it's not with everyone. Also, here's the thing. Here's what you have to remember. Okay, this is, again, Delphi. I know we use that for everything, but we lived it and we've never left it in some ways. Delphi, we're in Indiana. We live in Indiana. If you go up to a random person, they've probably, I think oftentimes they've heard of Delphi, at least when you're in Indiana. But sometimes they'll repeat back to you details that are just wrong, or they won't remember all of the details, or they'll kind of get it conflated with something else. And I think that's important to remember. People remember the high level stuff. They remember, oh my gosh, Charlie Kirk got shot. Remember that? They're not necessarily being like, did you see that filing? Wow, that was a doozy. They're not following it with that level of granularity. They're just not. And to act like they are is kind of to conflate the true crime community with everyone in society.
And we do have a time-honored system in place, the voir dire, the jury selection process, where we can weed out people who have been exposed to information and who do already have strong opinions about where that information leads them.
Yes.
The prosecution filed some stuff that kind of echoes some of the things the media was saying. Quote, the mere fact that a court has not ruled on the admissibility of certain evidence cannot be a sufficient basis for restricting access to a record discussing that evidence. End quote. So again, the defense wants to file something discussing some evidence, but they don't want people to be able to access that because apparently that information is bad for their client. And they were just worried that even discussing it in a public filing would be disastrous. The prosecution says, nor does defendant explain, even in general terms, why exposure to information about the evidence in the motion would so taint potential jurors that he could not receive a fair trial. As the United States Supreme Court has held, pretrial publicity, even if pervasive and concentrated, cannot be regarded as leading automatically and in every kind of criminal case to an unfair trial, end quote.
Mm-hmm.
The defense, of course, gets their licks in again, writing, quote, the news media frames its opposition to Mr. Robinson's motion with the absurd assertion that the defense seeks to litigate this case in secret. Nothing is further from the truth. again, they argue that this is just them trying to protect his rights, and they are very critical of the news media. Quote, the court and the news media need only to look to the news media's own publications since September 10th, 2025, to note the overwhelming emphasis on matters that have no bearing whatsoever on the public's ability to see how the justice system works, how this court makes its decision, and the role of the press in ensuring confidence in the public that justice is indeed being done. Rather, the news media uses their platform to, for example, call for Mr. Robinson's death, to have body language experts make irrelevant and entirely unscientific claims about Mr. Robinson's character, and to transmit video worldwide that is in clear violation of the court's orders, end quote. One more line here. It is entirely disingenuous for the news media to lay blame for harmful content emanating from their electronic publication of courtroom proceedings on secondary or subsequent publishers, end quote. So they're saying the news media is acting like they're doing this great and noble thing by educating the public about the nature of the trial process, but golly, some of their coverage isn't so edifying. Some of it is pretty bad. And even if they just take stuff, even if somebody is just using the feed and broadcasting the feed, other people out there are using it in their own ways. What do you make of that?
I feel like time is a flat circle, and we've gone back to the Idaho murders all of a sudden, because I remember a very similar tenor to some of their filings around the media, where it's like, they're trying to come kill our client. The news reporters are, storming in and they want him dead. Remember that? I think it was Jay Logsdon filed a really, really over the top filing about, like, these journalists are going to get our client killed. And it was like, okay, there was a little bit of like, it gets over the top. I think it's really interesting that they're conflating like all media. Like, I don't think CNN ran a headline saying, we want Tyler Robinson to die. And also it becomes meaningless to me, this might be controversial, but to me, when people are complaining about the media, which is something I do also. I'm breaking my own rule here, but like, I complain about the media, but then when I think about it, it's like, okay, there's a lot of different facets to that. It's kind of like complaining about law enforcement in the way that you might have some very good points, but are we talking about the FBI or your local police or the local county sheriffs or a large city police department or an individual squad on that police? Like, what are we talking about? Or are we talking about like practices that are generally done across the board or that are specific? And that's where I feel like with the media, things go wrong, because when, are we talking about national news outlets? Are we talking about the local news? Are we talking about highly partisan media outlets that are mostly kind of focused on the political aspect of it or kind of putting out a specific narrative? Are we talking about new media creators on YouTube and with podcasts who are often considered more unfettered and frankly more unprofessional about how they present things? Are we talking about just social media commentators? What are we talking about? Because again, I really doubt that CNN ran a headline or something about like, like we want this guy to die. That just doesn't, you can criticize CNN and maybe they're doing things in a way that you don't like, but like what they're kind of acting like all the media is doing is certainly something that all the media is not doing. And I don't know. When I see that kind of over the top rhetoric, it just kind of makes me roll my eyes a little bit, even though I know what they're saying and I'm sympathetic because listen, I've been very unhappy with a lot of media coverage of high profile trials. I feel like covering a trial and covering a case is becoming a lost art. Everyone likes the shallow takes, the quick updates, bringing on an expert who's just retired law enforcement to kind of spout about stuff. And again, sometimes that's great. Sometimes you have an expert who's great and can talk you through it. But other times it's like the reporters themselves are not doing the work necessary for them to really understand what they're covering. And they're relying on just, these kind of banal takes that then get made into sound bites. And I think, again, I see that happen a lot. So I'm sympathetic with that. But the idea that, frankly, the media has a bias against the client in this position, I don't know. What's the evidence for that? I mean, I think the big problem with the media in terms of bias is actually usually across the board, they want the best story possible. And that's unfortunate because sometimes crimes are not that interesting. And the best story is not really necessarily what the truth is. And so, like, to me, that's a bigger problem. But, again, with this, it's like, what are we talking about here? Let's be specific. Do they cite any, like, specifics here? Like, oh, these guys said this, and they're,
I'll talk about it in a second. But first, I want to say it's a cliche, but I think it's true. No one is happy with how they're covered in the media.
No.
So that's a given. And everything you said is true. A lot of coverage of crimes and trials is bad. A lot of coverage of everything, frankly, is bad. But, the last time I read the Bill of Rights, there was not an asterisk there saying, well, you only have freedom of speech if your speech is sufficiently edifying and doesn't do anything silly. If you go back to the age of the Founding Fathers, I'm stepping on your toes here.
Yes.
There was a lot of bad coverage of early American politics. A lot of vicious stuff.
Look what they did to John Adams.
Yes, we don't even need to go into details, but there's always been bad media coverage. It's not like bad media coverage was something that was invented in 2010. So if our founding fathers wanted there to be freedom of speech only to stuff that is sufficiently edifying, they could have put something in the Bill of Rights to that effect. So I think criticism of media coverage is fine and interesting, but to some extent it's irrelevant. And also I want to echo and amplify what you said, which is that there's also a distinction between mainstream media, social media, and all this other stuff, which I don't think they're addressing at all.
When you have mainstream media, the problem is typically, in my view, shallowness of coverage, misunderstanding key points, or having a subtle but certainly palpable bias for one side or another. That is something I've seen again and again. It's all unfortunate. Is it something that means like all journalists should be kicked out of the courtroom forever? No. I mean, what you want is just better coverage. But again, as you said, that's not really an issue here. When you're talking about the new media creators, things go off the rails in a bigger way. Things go off the rails in terms of people saying things like, oh, the defendant should be taken out and lynched. I mean, you do have that. So, I mean, that is more of where the Wild West is. The other side is not so much, but there can still be problems. This is why we often end up like touting local media coverage, because I sometimes feel like that's where things are a little bit more specific and grounded versus national media coverage. Not always, but sometimes. But, that's neither here nor there.
I want to wrap up here in a second, but before I do, you kind of inadvertently, I think, raised an issue I want to discuss with you that might make your head hurt.
Oh, no.
You said, Kevin, did the defense provide any listings or any examples of what they consider to be really bad coverage? Apparently in one of their motions relating to whether or not there should be cameras in the courtroom, they apparently included like a long list of what they considered to be bad media coverage. And I say apparently because I haven't seen it, because they filed motions saying, oh, this list of publicly available information should be kept private because if we republish it in court, it's going to attract more attention to it. But these examples they cite are already public. They're taking examples of things in the public discourse, which they say are bad, but then say people shouldn't be allowed to see these examples, even though these examples are already out there.
Do you think they're just trying not to tick off whoever they're criticizing?
I don't know. Again, their argument is, if, let's say there's something that says Kevin is really good looking, and I don't want people to know about that. So I want to keep that under my hat.
Yeah.
So if I say, here's an example of something I don't want people to see about me, I don't want to give it more attention, I may be reluctant to mention that because just by me mentioning, this particular article saying I was good looking embarrassed me, that might draw attention to it. That would be their argument, that by bringing it up, by talking about it publicly, they may be drawing attention to discourse and discussion that they feel doesn't merit the attention.
Right. I mean, that makes sense. I think it's really unfortunate that you put the Kevin is a cutie community on blast like that. But I mean, I guess that's, you don't want that out there. But that just seems okay. How like the kids say, you're doing too much. That's how the defense strikes me on some of this. At the same time, I understand it. I think like the Idaho defense team who were, defending a person who I'm not going to name because he deserves to be forgotten for what he did to those four young college students. But like them, they're put in a position where they're trying their best in a very wild media circus, and they're making decisions that frankly seem a bit egregious and maybe even a bit kind of dumb to us. But when you're in the center of the circus ring, I could perhaps understand them. I'm trying to empathize with that. I think I can understand it. I don't really think that all of these should be done because I think the harm of that is that I know they're saying we don't want a secret trial, but like, it seems like they want a lot kept in the dark. And I just think the harm in that is that, it undermines the public's ability to know about what's going on in an important case. And I don't think that's good.
Here's what the media said about it. Quote, the references the defense wants to keep secret are public information that in many instances are statements by the public. Put simply, the defense wants to deny the public access to public information, including publicly created information. The defense cites no authority for this novel argument, nor could it. What is public, and the defense cannot make public information secret by putting it in a court filing.
Wow, the media lawyers are on fire, I think. I mean, I like some of their...
Yeah, it seems bizarre. Here are things that happen publicly that I don't like. Oh, by the way, the public can't see these examples I'm citing. That's bizarre.
One thing that's interesting to me is the difference between the defense attorneys in high-profile cases who try to cultivate the media by leaking to them or by, kind of sucking up to them behind the scenes is something you and I have directly seen in front of our faces. But there's that side. And I find that also pernicious because I think that oftentimes is used to try the case in the media. And reporters always fall for it. Always. Because access is access. And that's also bad. I don't like that. In this case, I kind of respect it more because they're kind of just going to war with the media. It reminds me of Ann Taylor's team. It reminds me of that Jay Logsdon filing where it's like, hey, reporters, we don't F with you. Like, come fight us. And there's something more honest about that, I guess, because it's not trying to, like, manipulate things. It's more like, let's just fight. And I guess for some reason that makes me kind of, I don't know, it kind of amuses me. And I feel it's a bit more like, I don't know, more of Marcus of Queensberry rules, right? But at the same time, I don't think it's super effective. But again, they I don't read into it that, they have a terrible case and they're going to lose, definitely, necessarily. But it definitely indicates to me that, they're not posturing to win a popularity contest here, because going directly to war with the media is usually not an indication that you're trying to, get a bunch of flattering profiles in magazines.
That is true.
Which, again, I don't think you should be in defense, being a defense attorney to get that. I think you should be in it to do your best for your client, whatever that means, whether that means a really good plea deal, whether that means getting them acquitted or, whatever that means, that they should come first. And when I see defense attorneys do this, even if I don't agree with it, I at the very least feel like they're not show ponies.
I agree.
They're very angry workhorses.
The prosecution also made what I think was a good point in one of their filings on this. Quote, the court should also note that not all the pretrial publicity here has been adverse to a defendant. Much of the publicity has also created concerns for the state. A number of conspiracy theories out of this murder have circulated worldwide, end quote.
That's the thing. Okay, go ahead. You go ahead. Because that's why I'm so confused. Like, I think a lot of the pretrial publicity in this case, and just stuff we've heard, we've had some emails and some comments from folks who listened to our first episode, and And they were all very polite, and I really appreciate those people kind of sharing their thoughts with us. But a lot of them are kind of like, I don't know, I feel like there may be something weird going on here. That's bad for the prosecution, okay? Why the defense is also being like, no, we don't want any of this. I don't know what they're seeing, but most of what I've seen, I would think would be more bad for the prosecution and making people be more of like, Tyler Robinson is a patsy. He's getting set up. The government is behind this. And again, that would make you acquit if you actually believed that. So that's a little bit baffling, where I would almost expect the prosecution to be more on the side of like, let's lock it down. And the defense being like, no, everybody go nuts. Let's speculate. Who could have done this, And to see it be kind of the opposite is interesting. And I don't know what to make of that.
This is speculation, or maybe it's just an observation. You mentioned that in the Idaho case, the defense in that case took a similar posture to what we are seeing here. And I think one thing that those cases have in common is that in both cases, it was pretty readily apparent that the prosecution had a strong case.
And the death penalty is on the table.
Yeah.
I'm not saying the death penalty is necessarily influencing things here, but it's like the margin for error is your client might be executed. And yeah, to me, the strength of this case is something that should be noted. I think that is, yeah. I don't know. But at the same time, really though, like a lot of the kind of media frenzy around it, or a lot of the social media frenzy at least, would be something that would be more damaging to the prosecution.
And I think this is a good place to stop this discussion.
Can I actually add something though when we're talking about? I think because again we have heard from people, and I appreciated them reaching out certainly. I think though I guess like I want to talk about a concept that I do see a lot when we're talking about this case in particular, and it's unfortunately something that kind of gets thrown around a lot in other instances too. And I wanted to kind of like throw this out there to people because, I think I understand where people see a high profile case and they start saying, well, there maybe is more to it, or maybe this happened, so then that means that must have been the case. I just let's just kind of like talk about logical fallacies and how that can work. So there's a concept called, it's Latin, post hoc ergo propter hoc. That means in Latin, literally it means after this, therefore because of this. And that is an informal logical fallacy. That is an informal fallacy that essentially it means an informal fallacy is like an argument that's illogical. And what it means is that because event, this is how it's literally defined. Because event Y followed event Y must have been caused by event X. And the way I see that formulating in this Charlie Kirk murder with Tyler Robinson is there's a perception of Charlie Kirk's death benefiting the current presidential administration by making Charlie Kirk a martyr or distracting from other events. That's what I'm not saying that myself. I'm just saying that that's what I've heard. People have said, well, I think that death benefited people in power because it caused all this chaos and it did all this. And therefore, it makes me suspicious that the people in power caused his death. That's a logical fallacy. That is the same logical fallacy that prompts people to say that because, let's take a mass shooting. Let's take a really heinous mass shooting. A mass shooting happens. People get outraged. People start calling for gun reform, gun control. They start saying, we need more gun control. We can't have all these classrooms of kids getting shot and murdered. And we have conspiracy theorists come out of the woodwork and say, well, I actually think that this was a false flag operation set up by people who want gun control because the ensuing outrage benefits people who are in support of policy goals towards gun control. So it's really important that we set aside that kind of thinking. It's not logical. Okay. It's not, it's, I mean, do you hear what am I making any sense?
Yes, you are.
I understand it. It's an attractive mode of thinking. It's an attractive mode of thinking, but it is also not logical, and it does not have a place in this. In order for, if we're looking at the concept of Tyler Robinson being some kind of patsy for a long, either being one, framed, or two, being kind of lured into something and encouraged to do something by powerful people, that is something that if that is to be borne out, then it needs to be borne out by evidence. That's not something that we can kind of play games about and say, well, maybe he's been threatened. At this point, he's facing the death penalty. I mean, this, what is more threatening? If he has something where he is able to say, hey, look, see, these people got me to do it, or, here's the frame job. Great. We'll all hear about that in court, I imagine. And if there's nothing there, then there's nothing there. And acting like we have to, that's not, again, I'm just asking people, let's follow the evidence. Let's look at the evidence. And if the worldview that you're adopting is that the government at both the state of Utah level and county levels in Utah and the federal government and all of these people who worked on the case and the prosecution team and even people close to Robinson, including his romantic partner and his family, are all in on this, then I would just ask you to question, is that really feasible? Is that a realistic scenario? Because maybe I'm wrong. Maybe there's a smaller, leaner conspiracy that could fly here. But for my view, looking at the evidence as presented in the probable cause affidavit, if we're going to go with a conspiracy route, there needs to be a lot of people involved in making that happen and making sure it runs smoothly. And I just find that very hard to believe. And I think it's important that even though people have very strong feelings about this case because of the politics, you have a lot of people who very much are upset about Charlie Kirk dying. They agree with his politics. They are very upset. They feel under attack by this. And then on the other side, you have people who didn't like his politics. And they didn't want him dead. I mean, they didn't want that to happen. But they feel like maybe his death is being used as something more sinister, right? And in either way, it's important to kind of maybe set aside some of those feelings when we're talking about the cold facts of a murder and look at something. I will add that there are instances where, law enforcement gets to a person who might be planning an attack and they kind of encourage it so they can arrest them, right? And there are always questions of entrapment around that. But that can come out in court and that can benefit a defendant. Look, my client was vulnerable and maybe mentally impaired, and this FBI agent said, hey, let's do a terrorist attack, and then suddenly they got caught up in this. So, there are defenses around that. I feel like if that's something that's the case here, we would hear about it from this defense team. I don't think it's helpful for us to be just looking at things through the lens of a logical fallacy.
I think that's very well said. So today in this episode, we talked about the defense's concern that the public, potential jurors, could be influenced by some outside forces in this case, namely media coverage. I think in our next episode, we're going to look at the defense's concern that the prosecution team itself was influenced by an outside force, namely the fact that a relative of one of the prosecutors witnessed the crime. Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
At Verbo, we understand that even the best of plans sometimes need a little support, so we plan for the plot twists. Every booking is automatically backed by our Verbo Care Guarantee, giving you confidence from the very start. Whenever you need help, it's ready, before your stay, through the moments in between, and after your trip. Because a great trip starts with peace of mind, and maybe a good playlist. But we've got the peace of mind part covered.